Good evening. This is Stephen Leskin, and thank you for joining me. Tonight's webinar is dividing up marital assets in a divorce. And this really is going to be a deep dive. We're going to go into how the courts look at property, how the courts look at debt, and we're going to discuss how those things get played out during divorce. As always, I don't take questions during the webinar, but I am more than happy to take calls and emails afterwards. So if there's a question on your mind, please feel free to shoot me an email. Please feel free to give the office a call. I'll have contact information up at the end. You can, of course, find me at www.leskinlaw.com if you want to look up my website and get a little bit more information about me. So tonight we're going to start off by going into a little deeper dive into what we're going to do tonight, and I'll explain a little bit more what the game plan is. We'll then get into defining terms. There's going to be a lot of basic stuff that we'll cover tonight. We'll talk about some myths surrounding the big myth. There's one big myth surrounding how property is divided in divorce. And then we'll turn to the statute, the Oregon law that authorizes and directs the court how to divide property. And then finally, we'll talk about how assets are valued during a divorce. Again, my name is Stephen Leskin. I've been practicing law in Portland and in Oregon since 1992. Been doing family law since 2001. Most of my practice, 90% of my practice, is divorce. I do a lot of mediations. Primarily, I am a mediator at this point in my career, but I have been litigating for more than 30 years. And for those of you who are interested, my office is in Northeast Portland, close in. All right, so let me get into the deep dive. I call this a deep dive because it's an hour on a particular topic related to divorce. We'll spend about the next hour talking about how assets and liabilities are divided in an Oregon divorce. I just want to say we somewhere there was a mistake in our publication. Uh, if you're here for the child divorce and children webinar, we did that 2 weeks ago, and that is now up on the website. You can find that on the leskinlaw.com website under resources, and then there's a tab for webinars, and it's going to be the first one since it was done most recently. Tonight is assets and liabilities. The I don't know what happened. I don't know where the publication got screwed up, but you can find if you're here to watch the children and divorce series, you can find it on my YouTube or on my website. My intention with this deep dive is to give people more information about what happens during divorce. I've found through my own practice that the more people have knowledge about what Oregon law is, how things happen, the easier it goes for them, and particularly if both spouses are on the same page. Once people have an idea of what the law is and what the facts surrounding their case are, it makes it that much easier to resolve. And that was a big insight of mine when I put together my one-day divorce mediation process, was that the more information people share and can agree to, the more easy it is to get to a resolution. And so part of what I'm doing here is trying to put that information out to the public. If you're going through a divorce, uh, maybe you want to watch this with your spouse, maybe you don't. But having a common background of information will help you resolve, should help you resolve your differences. There's a shark motif that runs through my deep dive seminars, and it's because I picked this motif because once you start going deep, you start getting into trouble. You find that there's more details. A lot of times, the devil is in the details. Uh, Even at an hour, I probably could go for another hour on any of these topics. Uh, but um, and I also just like the shark motif. Let's just be honest. So it's really not a great metaphor, but I like it. And I do like the metaphor of attorney or shark as attorney, not necessarily attorney as shark. But sometimes, just to get back, sometimes the material is complicated. Sometimes the the detail, the decisions and the outcomes are guided by the details, and that does take a lot to get through. And so, even in tonight's seminar, um, we're going to be talking at depth, but I could still, easily go another 2 hours on this topic without breaking a sweat. So let's get into it. Uh, we're going to talk tonight about how assets and liabilities are uh, divided by the court. But let's start with defining our terms. What's an asset? What's a liability? And some other things. So let's just jump into it. An asset can be any real or personal property. So personal property is your cell phone, your computer, your car. Real property is any land, a home, condominiums. Uh, so real property is always connected to the earth. It's those things. It's your home. Uh, Personal property is anything else. Personal property includes every other physical item in the universe, right? That you own. So my cell phone, which is on my desk in front of me, that's an example of personal property. And personal property is always physical, as opposed to intellectual property. And intellectual property is something that somebody owns as a right under a contract, maybe even as I was going to say even under a statute, but that's not correct. Uh, Intellectual property is an asset is an asset that's a right that's given under a contract. So if you think of cryptocurrency, right, you have a right to a value that's given to you under the crypto contract. If you have rights to photographs or music that's given to you under a contract that you can then negotiate, trade, and value as you would any other piece of property. Assets also include bank accounts, retirement accounts, savings, and checking accounts. Those are all assets as well. Uh, Pets are also assets. We treat in divorce setting, we treat pets as an asset. They're also kind of denominated as sentimental items, but pets are definitely considered an asset. They are not valued like you would value a house or a car, but they are considered a species of asset. There's two different types of assets uh, generally. One is a titled asset, and the other is a non-titled asset. And this is important in terms of ownership. I mentioned that my cell phone is on my desk here. Uh, my cell phone is not a titled asset. I don't own it because of I have a title to it or deed to it. I own it because I possess it. Right? It's mine. The saying that we all know, possession is 9/10 of the law, is true. If we think about cash, for example, the cash in my wallet is mine because it's in my wallet. I have no other claim to it. If I lose it, and somebody says, "Well, I found $20 on the sidewalk," um, I have no way of proving that that's my money, as opposed to a titled or deeded property. So, for example, if you have a deed to your house, you own the house as reflected in the deed. If somebody takes possession of your home, they do not own it. It's the deed that denominates ownership. And that's why there's so many protections around deeds and other titles. We notarize them, we put them out, we file them with, particularly with deeds, we file them with the county and we record them so that the public can see that we own this property, this real property. So if somebody steals my car, they don't own it by virtue of um, their possession of it. They own it by virtue that they have the title to it. So two different types of property. One is titled, the other is non-titled. What is a liability? A liability is a contractual obligation to pay money, right? So you have a credit card, you have a contract with the credit card company, they advance you cash, you're obligated to pay them back. Uh, I could enter into a contract with a friend of mine for a loan, and I'm contractually obligated to pay that person back. That's uh, a liability. So a liability could take the form, like I said, of a credit card. It could take the form of an account at a store, a utility bill. Uh, I could have an account at Home Depot, for example. Uh, all of those things are accounts. They're a liability because you have an obligation to pay them back. The money's going out, right? That's what makes it a liability. Uh, a court, you could also have a liability in the form of a court judgment. In specifically in divorce, there may be an equalizing judgment against a party, meaning that husband, for example, owes wife money under an equalizing judgment. Say it's $50,000. That judgment, which arises as a result of a court order to pay money, is also a liability. Liabilities can be secured or unsecured. A liability that's secured is secured by collateral. So uh, uh, when I take out a car loan, that the car itself becomes the collateral. And if I fail to make payment on the car loan, the creditor, the lender, can take back the car. It's secured. Same with a home mortgage. If I don't pay on the mortgage, right? If I don't pay my loan on my house, the creditor, the lender, can take back the house. So there's secured and unsecured. And of course, unsecured would be like a credit card where there's no collateral that backs up your obligation to pay back the loan that you've incurred. So, like I said, home mortgages are secured by the collateral on the house. Unsecured liabilities have no collateral. So let's, with that little bit of backdrop, let's get into ownership of assets during marriage. So who owns what during a marriage? Uh, the key issue to understand, the most important part of understanding this, is what assets could be subject to third-party seizures. So, for example, if a husband or wife doesn't pay a loan, what assets of the marriage can the creditor seize to make good on the judgment to collect on a defaulted loan? That's the key issue: is what uh, what property in the marriage can be seized. Oregon law is actually pretty progressive about this and has been for more than 100 years. It's actually enshrined in the Oregon Constitution that a creditor cannot go after a wife's property to pay a husband's debt. There's a huge exception to that. I'll come back to it at length in just a little bit. But generally, creditors cannot attach property of a spouse to satisfy the debt of the other spouse. Uh, so Oregon law provides that one spouse is not liable for the debts of the other civil liberties of the other spouse, except, and here's the exception, and it's a big exception, both spouses are liable for debts incurred for the family. So family debt. Expenses of the family, oh, there's a mistake there. Expenses of the family include only expenses incurred for the benefit of a family member. Now, if you think about it, this is extremely broad. What between my wife and I, for example, we're both spending for food, entertainment, gas. Those are all. Supposing I had a Chevron gas card that I ran up a big bill on and defaulted. Um, that is a family debt because it's incurred for the benefit of a family member, right? And so the Chevron could come after me for payment on that bill. They could also come after my wife, right? So any debt that's incurred for a benefit of a family member, the creditor can go after either party. That language is very broad and inclusive. And so there's very few, I'll get into what is not included in family debt, but it's very broad and it's very hard to come up with, spending that's not for the benefit of a family member. Uh, the family debt expenses of the family member is found at ORS 108040. It includes, excuse me, I spoke. It excludes such things as spending on vice. So, for example, if you owed a lot of money to your bookie couldn't go after your spouse. Other crime, drugs, prostitution, those are obviously all things that are excluded. Those are not family. Those are not charged to the family. An interesting situation that comes up a fair amount actually is debt incurred on behalf of a LLC or a corporation. An individual is not responsible for corporate debt, but for LLC, it's a little bit different because debts are passed through. So somebody can have LLC with a lot of debt, but the question is whether or not the spouse is on the hook for that. It's not necessarily an expense for the family member, those LLC debts. It's debt incurred for the benefit of another entity. So my view has always been and continues to be that debts incurred on behalf of a corporation or corporate like structure remain with the corporation, and those creditors who dealt with the corporation, they could make the judgment about whether or not the corporation was a good investment or not. A little bit of a digression. So uh, another issue that comes up a lot is whether or not a spouse has a legal right to sell a titled asset in the name of the other spouse. So I buy a car, it's in my name, only my name is on the certificate of title. Can my wife sell that? Uh, and the answer to that is no. Uh, unless is no, unless there is a written permission uh, uh, for the spouse to act on behalf of the other spouse. So, in other words, just because you're married, you're not power of attorney for one another. So, my wife could not sell my car without my written consent to her signing and transferring title. Right? Uh, there's no inherent. You don't gain essentially a power of attorney just by virtue of marriage. Uh, so same as a power of attorney, an attorney and what we're talking about is an attorney in fact. An attorney in fact needs to be in writing, which gives it the same powers as a power of attorney. So I'll just repeat what's on the slide again. Uh, I can't sell my wife's Porsche without her permission for a lot of reasons. So um, if she says, you have my power of attorney, you have my written permission to sell my Porsche, then I can go ahead and sign my name or her name on the title. If I was going to sign her name, it would be her name by Stephen Leskin, POA, power of attorney. And that way it's clear I'm acting in capacity as an agent and not as a principal. All right, so that's a little bit of background information. That's defining terms. And now we'll get into a huge myth surrounding how property is divided during divorce. Looks pretty dramatic, huh? All right. So if you call an attorney, you find somebody online and you say, I want to know how my property is going to be divided. They will tell you that the longer you're married, the more the court is going to split your property equitably, meaning evenly. The less time you're married, the more the court is going to attempt to put you back into the position you were in. That's so generally true that it doesn't really hold any water. It's too simplistic. Uh, and so now we will get into what the courts actually look at in dividing property. So let's turn to the Oregon statute. And I'm going to read this. It's Oregon Revised Statute, ORS 107-105. And this is the actual statute that gives a judge the authority to divide the property of spouses uh, during divorce. Uh, as we talked about, property remains separate during a marriage, but during a divorce, uh, the court can divide or appropriate either property as it sees fit. So there's a lot of power a judge has in the name of equity during a divorce. Excuse me. I bet there's something coming out of my nose now. Okay, so um, the language that we're going to look at says, for the division or other disposition between the parties of the real or personal property, or both, of either of the parties, has may be just and proper in all the circumstances. In determining the division of property under this paragraph, the following apply. A retirement plan or pension or an interest therein shall be considered as property. The court shall consider the contribution of a party as a homemaker as a contribution to the acquisition of marital assets. And finally, except as provided in subparagraph D, which we're not going to talk about, but deals with gifts to parties during marriage, there is a rebuttable presumption that both parties have contributed equally to the acquisition of property during the marriage, whether such property is jointly or separately held. And now we're going to go through each of those sets of buzzwords. All right. So the statute used the language just and proper in all the circumstances. What does that even mean? And how do you think about something that's just and proper to me is not going to be just and proper to my spouse? And what does in all the circumstances mean? Right? I mean, wow, that's so broad and vague. How could you uh, the statute is just so nebulous that you have to ask, how could a court use this language to justify uh, um, dividing property? And I'm going to go through this with you and show you how the courts work in this circumstance. So there's property acquired before the marriage, and that's known as a marital asset. There's property acquired after the marriage, which is known as marital property. And this applies to both jointly held and separately held property. The statute also used the language presumption of equal contribution. So this is really important, and it comes up a lot that people say, my spouse did nothing but sit on the couch. My spouse did nothing but sit on the couch and eat bonbons. My spouse sat on the couch and did nothing but eat bonbons and watch Oprah. My spouse, anyways, you get it. So on and on. And the courts say that you can rebut the presumption. The statute says that there's a presumption of equal contribution. So people will come in and say, my spouse didn't do anything. They sat around during the whole marriage. That's the person you married. The court is not going to judge that person for being a slouch. That's getting into character testimony, and the courts don't judge people on their character, only their conduct. So equal contribution means that the person was present during the marriage, or did not contribute financially at all to the marriage. So, for example, two people who have separate bank accounts, there's no commingling, and one party lives in the house, the other party's paying all the expenses. That might be like, you might be able to overcome the presumption of equal contribution. Over the years, I've had several cases where this has come up. I had a case many years ago I represented the wife. They got married later in life, which is also important. And they did not commingle their assets at all. He had his bank account, she had her bank accounts. There was no joint savings account. There was no retirement accounts together. And Um, she constantly made improvements to the house where they were both living, and he didn't contribute a single dime. But he came back to the court and said, "Well, I want my share of equity in the house for the time that we were married." And under those circumstances, the court said there was no equal contribution to the house. You do not contribute to the upkeep of the house. You do not contribute to the repairs of the house, uh, uh, and so you don't get any of the equity. In that case, there was the wife, overcame the presumption of equal contribution. Uh, but just by the fact that somebody sits around the house, that's not enough grounds to overcome that presumption. One of the most important factors that the courts look at is the intention of the parties and how it's expressed in how they manage their financial affairs. This is from an Oregon case, cases Jenks and Jenks, uh, and the court said in that case, if the marriage is terminated before the parties' financial affairs become commingled to the point that the parties cannot readily be restored to their premarital situation, then property division is a relatively simple task in the nature of rescission. They both go their own ways. That's what the rescission is. You both going your own ways. And so, like I said when I discussed the myth, um, it's not a function of duration; it's a function of intention. Parties can have a short-term marriage, supposing that the marriage is 2 years old, but coming into it, wife sold her house to put the money into a house that they both could jointly live together. Well, that when the house gets sold, uh, uh, wife um, is going to be made whole again, right? Because the intention was to live together as a couple. So in those circumstances, wife is going to get her investment back. Uh, so the intention of the parties is what governs, not just particularly the duration of the marriage. Generally, as a matter of course, the longer couples stay married, the younger in life that they are when they get married, the more commingling. If people get married later in life, when they already have their financial affairs and maybe they have kids and they want to leave things to their kids, they intentionally don't commingle, then the court's going to separate them along the lines that they live their life together. The assets aren't going to be commingled just as a result of getting divorced. So the intent of the parties is really what counts. All right, we're going to get into the key case that interprets ORS 107, 105, the section of the statute that governs um, how the courts will divide and allocate property and debt. Coons was a seminal case that came out in 2004. I remember when it was uh, released and decided, how much discussion there was about it. It's a little bit complicated. And whenever I have a case that involves division of property, I always have to go back and reread the case to make sure it's straight in my mind. But I'm going to explain it, and this will give you some insight into how the court works. Most Coons analysis uh, deal with property in real estate. I misspoke. Equity in real estate, right? So usually that's the biggest asset in the marriage. So the courts will look to um, Coons for a direction of how to split up um, equity in the house. I would start by saying that Coons divides, as I just mentioned, property into property and marital assets uh, uh, for whether the property was obtained and purchased before the marriage, and then property that was obtained during the marriage. Uh, and the important thing to know is that the court in a divorce case has jurisdiction to decide any of that. So if you come into a marriage with $1 million in real estate, and uh, uh, the court theoretically could take that $1 million and give some portion of it to your spouse, even though it was paid off and owned outright before the marriage. The court has jurisdiction over all of that, and that's um, kind of a bedrock principle of divorce. Is that that's the court is not limited in what uh, personal or um, real property it can allocate to get to uh, the just and proper in all the circumstances decision. So, like I said, the Coons Court draws a distinction between property acquired before the marriage and after the marriage. And so I'm just largely repeating what's now in the slide. Assets purchased before the marriage are also subject to the jurisdiction of the court and can be allocated to effectuate a just and proper division between the parties. So, like I said, marital property is property acquired before marriage. Uh, um, in dividing up assets of marriage, the court needs to consider whether or not there's an equitable contribution to the premarital asset. And usually the answer to that is no. But in making its decision, the court has to look at certain social policies which are considered equitable considerations of the marriage. And those equitable considerations include things like preservation of assets, achievement of economic self-sufficiency for a spouse, particular needs of parties and children. So, for example, if there's disabilities or age issues, those will also count as factors in achieving a just and proper, in all the circumstances, division of assets. And getting back to the big one is commingling. A separately purchased property acquired before the marriage that's used to support the marriage may be certainly may be divided, uh, not on it, maybe divided at some level, maybe not 50-50, but maybe used to get to the just and proper uh, division by the court. And so, just again, I can't put too fine a line on this. The court has authority to divide property acquired before the marriage and during the marriage. Marital assets are assets acquired during the marriage. And this applies to whether or not assets are acquired in a person's own name or whether it's jointly titled. So, for example, if a couple went out and bought a car together, both names are on the mortgage, on the loan, and the car is titled in both names, that doesn't matter. It doesn't change how the court divides the property. Even as opposed to the car is titled in just the husband's name or the wife's name. The court can still move those assets around to achieve its just and proper ends. Um, the first question that the court is going to ask after it determines whether the asset is acquired before or during the marriage is there evidence to rebut the presumption of equal contribution, right? So the second step in the Coons analysis uh, is there a reason that the other spouse shouldn't have part of this asset? Did they not contribute? Can I overcome the presumption of equal contribution? So, for example, a house has $100,000 in equity in it, and the court's going to say, well, I'm going to give, it's a long marriage, I'm going to give both parties, $50,000. Uh, that could change if one of the parties came and said, well, uh, the spouse took off. I haven't seen the spouse in 5 years. There's been no contribution to the asset. So in those circumstances, you could rebut the presumption of equal contribution and attempt to obtain the entire amount of equity in the house. So this third step in a Coons analysis is the equitable considerations. Again, preservation of assets, achieving economic self-sufficiency, particularly needs of parties and children, and again, how much commingling there's been during the marriage, commingle of assets and debts. Uh, so that's pretty much it on how the court is going to value assets. In order to, and then I misspoke. It is going to divide the assets. Uh, debt is the allocation of debt is going to be along the same lines. It's going to also come within that just and proper in all the circumstances criteria that the court uses. Usually, um, a debt that's secured by an asset travels with the person who gets the asset. So very rarely would the court say, okay, wife gets the car, but husband gets the car payments. In that type of situation, the husband would be ordered to pay spousal support with enough to cover the car payment. But rarely, for all kinds of reasons dealing with the creditors, the debt stays with the collateral. Uh, and so generally, the longer the marriage, the more, if there's no overcoming of the presumption of equal contribution and there's no social equitable factors to be considered, in those cases, the court will attempt to split the marital estate uh, evenly, equitably, which usually means evenly. Not always, but evenly is generally what it is. Sometimes parties will come in and say, well, I should get the long half of the marriage, like, the 60-40, because I was the earner during the whole marriage, and that's not going to carry any weight. Homemake, the old expression, which is still in the statute, homemaking, uh, that's considered part of an equal contribution to the marriage. Uh, it's not discounted because it's not monetarily remunerated. You don't get money for it. So um, other reasons would be that somebody could come in and say, I should have the long half of the marital estate, the 60% over the 40% is because the other person was abusive. That doesn't come into this calculation. There's no room for that in this calculation. So even if somebody uh, beat somebody and sent them to the hospital, you would not get anywhere with the argument they beat me, so therefore I should get the long half. Uh, you could still sue a spouse, and I've never done this. I wanted to try it, uh, and say, well, I have damages as a result of your assault on me. That should come out of your share of the marital estate, not the marital estate in general. Um, uh, but I don't know that, I've never seen that done. I would like to try it sometime. But that would be one way that you could get, some share of the marital estate as a result of physical abuse. Um, so let's turn to valuing assets. Let's start with what is equity. In this case, it's financial equity, and equity is always the market value of an asset minus the amount owing. So, for example, if a house has a market value of $400,000, it's appraised, or you look at Zillow and it says $400,000, and 200 is owing to the bank, the equity is the balance, is $200,000. And that's true. Equity, that principle applies to your car, your work tools, anything where there's a loan attached. That the equity is going to be the market value minus um, what's owing on it. If an asset is paid off, market value and equity are equal. Uh, and assets are valued in the divorce setting. Assets are valued at market value, not replacement value. Sometimes people say, well, I just bought a new car, it's lost value, and blah, blah, blah. It should be if I have to replace it, it should be at the replacement value. It's not, it's at market value, not, it's what you could buy the object at, market, not how much it costs to replace new or something along those lines. The other thing I would add, and this is important, is that it's not in the slide, just occurred to me that I left it out, is that assets are valued at the time of the divorce. So it's important to know how much is in the bank accounts. It's important to know what the retirement accounts are worth. It's important to know how much debt there is at the time of the divorce. So it's impossible to say, on any particular day, exactly how much is in any retirement account because the stock market's going to fluctuate, or how much is in a bank account because we all have automatic withdrawals now, and so it may be higher, maybe lower, but it's going to be valued at the day of the divorce, generally, as close to it as you can. Uh, I'm going to go back a slide. I'm not quite ready to finish up yet. So during um, a divorce, parties will produce something called UTCR 8.010 statement. And for parties who, the courts require this, and the assets and liability statement, the 8.010 statement, is a spreadsheet, and it shows the value of the asset is this, husband's going to get this, and wife is going to get this. Uh, Debt, there's this much debt, wife is going to take this, wife, husband's going to take that. And at the end, the bottom numbers always have to equal one another. And that way the court can see that its distribution is going to be equal. It's not always the case that it's equal. There may be reasons to vary that. If parties don't want to come up with an equal contribution or don't care about coming out down to the penny, you don't have to produce that. A lot of times when I mediate, well, and if you're going to do it right, that means valuing all of the personal property. So like you would have to value all of the personal property in your house. And think about how crazy that is. How much are you going to value the dining room table for? How much are you going to value the hammer for, or the towels? Or you can't do it. It's crazy. Sometimes people want that though, and generally uh, those numbers are arbitrary. Uh, but those are what goes into uh, uh, the UTCR 8.010 spreadsheet. When I settle a case or mediate a case, for example, uh, uh, I will say you're going to take the property in the living room, you're going to get the property in the kitchen if it's not already divided, and we're just not going to value that. One of you is going to have to replace some of it. If one party gets the entire household furnishings, well, then the other party has to pay half of the value of that, representing their half interest in the home furnishings. And so that's not done down to the penny. I've had plenty of cases in the past where people want it down to the penny. The courts require it down to that. And sometimes there's, just kind of like a, best guess of what the property value is, and then you work with that. Uh, the other thing I would say is that if you, I didn't discuss this earlier, and what is an asset? Uh, Retirement accounts are their own species of property, particularly if it's a pension. If it's a 401k, you can know how much it's worth anytime. But valuing pensions is usually a job of an actuarial, and that is usually something that's not within the competency of an attorney to value. So uh, when you value assets like that, it's usually going to require some kind of professional to come in and give an opinion about, the actual aerial value of a retirement account. So now I'm going to hit the next button, and I'm going to say thank you for watching. Um, I hope this has been informative to you. If you have any questions about what I've covered, please feel free to give me a call. Here's my contact information. I'm happy to discuss things with you. My office is in Portland. Send me an email. Don't drop by the office, but please feel free to give me a call. And with that, I will say thank you for attending tonight, and hope to see you next week or in 2 weeks.